The last case is MEADOWLARK Investment Group versus GVO. Good morning. How much time would you like for rebuttal?
I'd like to reserve 5 minutes, Your Honor.
5 minutes? Okay. The yellow light will start to come on at the table there when you're into your rebuttal time.
Thank you, Judge.
All right, you may begin.
Good morning. May it please the Court. I am Patrick McGee. I represent the appellant MEADOWLARK Investment Group, LLC, a trustee of the 1005 Kimball White Trust. In the proceedings below, my client sought to vacate a tax deed regarding a residential property that my client owned. And the issue presented in this appeal is whether there was substantial competent evidence presented at trial to support the findings of fact that the Orange County Comptroller took additional reasonable steps to notify the property owner, MEADOWLARK Investment Group, LLC, as trustee of the 1005 Kimball White Trust, of the tax deed sale.
What should they have done that they didn't do?
Well, they might have started with first properly identifying the name of the property owner, and had the comptroller taken the same steps in the name of the property owner and directed to the property owner that it took in relation to what it viewed as a separate legal entity, 1005 Kimball White Trust, we would not be here. In this particular case, we cannot correctly identify the property owner, the title owner of the property, without using the words MEADOWLARK Investment Group, LLC. The ownership and encumbrance report that was provided to the comptroller used these words to specifically identify the title owner, but the comptroller did not. And this is a massive point that cannot be disregarded, and it has constitutional significance under the facts of this case. The comptroller instead erroneously believed that the owner of the property was a separate entity, 1005 Kimball White Trust, and that was the testimony of the comptroller's representative, Christine Willis, at trial. And she said that when the comptroller's office was tasked with delivering the notice of the tax deed sale to the property owner, that she viewed the owner to be 1005 Kimball White Trust, and she testified that MEADOWLARK Investment Group, LLC, was not the owner, but instead was an interested party. Now, had the comptroller...
But there was testimony that you knew you didn't pay the taxes.
Oh, yeah, yes, Your Honor.
Was there an attempt to post notice on the property?
On the property, there was, before the certified mailings were returned, but the posting was directed to and in the name of 1005 Kimball White Trust.
Well, if it's your property and it's posted on your property that the taxes haven't been paid and you know you haven't been paid, I mean, wouldn't that be sufficient notice that you need to pay your taxes or suffer a tax deed?
Under different circumstances, perhaps. The facts of the...
Well, I mean, what makes the circumstances different in this case than any other? I mean, you own the property, you knew you didn't pay the taxes, they attempted to post a notice that the tax deed was going to come through if you didn't pay the taxes, although it may have been in a different name. I mean, wouldn't that be appropriate notice that, that you needed to pay your taxes?
Under the particular facts of this case, no. And the property was occupied by a tenant, and she testified at trial as well. The tenant had a lease of the property that was in the name of the property owner, MEADOWLARK Investment Group, LLC. Apparently, the trial court rejected the notice the testimony of the tenant, Ms. McFadden, that the notice...
Isn't it basically the efforts of the controller that are important in this particular case? What efforts did the controller make? I also think that they did some research on the database to determine, didn't they? Didn't they do some extra research?
Not as to MEADOWLARK Investment Group, LLC. They did as to 1005 Kimball White Trust.
So they did some additional research. You're saying that simply because they put the wrong name as the owner, that relieves you of the liability in this particular case?
I would think that if I were the owner of the property, that a notice should be directed in the name of the owner. And if you follow through the facts of this case, the particular facts of this case, and I don't want to ignore the fact that you said the property taxes hadn't been paid and my client knew it. We cited case law in our brief that said that that's fine, but that's not notice that there's an upcoming tax deed sale. The particular case. Let me come back to that. It's in our brief. It's a Florida case. Says it's not the same thing. The facts of this case were that there was an ownership and encumbrance report that was provided by the tax collector's office to the comptroller's office. That's in evidence as the plaintiff's exhibit 4 at trial. That ownership and encumbrance report expressly identified the title owner of the property as MEADOWLARK Investment Group, LLC, trustee of the 1005 Kimball White Trust. The comptroller's representative, Christine Willis, testified that when she received these materials and she commenced her task with notifying the property owner of the tax deed sale, that the 1005 Kimball White Trust was the owner. She ignored the fact that MEADOWLARK Investment Group, LLC, was included in the name of the ownership and encumbrance report in Plaintiff's Exhibit 4.
Notice was sent to MEADOWLARK, wasn't it, initially, by certified mail? Just unclaimed?
There were 2 notices that were provided by certified mail, and they went out on April 3, I believe, 2015. One of them, they were both directed to the McGuire Road address, which was a bad address.
You were directed to MEADOWLARK, and then you cite the Jones case to say you need additional steps like posting on the property. But nowhere does it Jones say that it has to be subsequent, right?
Well,
here they did it at the same time. They sent by certified and they posted. It doesn't have to be after the mail is returned.
Yes, it does.
Is that what Jones says?
The Jones case does not make that point, but we cited a Florida Supreme Court case in our brief that does. The Patricia Weingarten versus Jockelbro case, I'm sorry, that's a 50 CA case. In Jockelbro, in footnote 2, it rejected the argument that the sheriff's posting prior to receipt of the unclaimed letter satisfied the Jones additional steps. Specifically, that court said Jockelbro argues that the attempted service by the sheriff satisfied the additional steps required of Jones. However, the attempted service was done 12 days before the certified mail notices were returned unclaimed. And in this case, the posting that was done on the property was not only done before the certified mail was returned,
Wasn't it done on the same day? Am I wrong? I thought it was done on the same day of the return of the certified mail.
Well, let me clarify that. The posting on the property was on April 9 at 7:05 p.m. The certified mail that was returned for both 1005 Kimball White Trust and MEADOWLARK Investment Group were marked by the post office on April 9 as return undelivered. So giving every benefit of the doubt as to when this happened, it didn't happen before 7:05 on April 9, 2015. It should have happened at the earliest on the following day, April 10, 2013, the day after it was processed by the Postal Service. The Jones case as well talks about the standard, if I could, Judge Harris, to follow on that point. While the Jockelbro case expressly dealt with the timing before or after the certified mailing is returned, the language of Jones versus Flowers, on which Jockelbro relied, does speak to that point. It says that when a mailed notice of tax deed sale is returned unclaimed, the state, as a matter of due process, must take additional reasonable steps to attempt to provide notice to the property owner before selling the property, if it is practicable to do so. And in this instance, in the Jockelbro case, dealt with that, and there must have been some attorneys trying to make a fine point of it and say, we took additional reasonable steps, we just did it before the certified mailing was returned. That's not what the standard, the constitutional standard in Jones versus Flowers speaks to. It speaks to what must be done in reaction to the fact that the efforts by the state to notify the property owner of an upcoming tax deed sale failed. And in the Jones case, it further talked about that point of why we have this standard, and it cited the Mulaney case and the gravity of extinguishing an ownership rights in property. It said in Mulaney, we stated that when a notice is a person's due, the means employed must be such as one desirous of actually informing the absentee might reasonably adopt to accomplish it. You know, what would somebody do to reasonably accomplish this? And then the court went on to say, we do not think that a person who actually desired to inform a real property owner of an impending tax deed sale of a house he owns would do nothing when a certified letter sent to the owner is returned unclaimed. So the reasonable steps that were required by the comptroller's office came into play after it was notified that its attempt to reach the owner through its certified mailing was unsuccessful and it was returned unclaimed. And then in this case, what we look at is what the state did at that point. What did the comptroller's office do? And Christine Willis testified that she made a Sunbiz search, that she tried to find the further information by searching Sunbiz. The problem, compounded again, was that she did not follow the specifics that were in the ownership and encumbrance report by searching for the title owner of the property. She searched in the name of the trust, which was not the legal owner of the property, and turned up nothing on Sunbiz. And she testified that she searched for 1005 Kimball White Trust. She did not search for MEADOWLARK specifically. She said, what we do is, if it's not an individual owner and it appears to look like a company, we search Sunbiz. It's just an additional attempt to find an address. Question, is that your ordinary course? That's your ordinary course, correct? And she says, correct. And then with the question that she was asked, so had you identified MEADOWLARK Investment Group, LLC as the owner, you would have, in the ordinary course, searched Sunbiz, right? And she says, right. Question, but since you did not identify MEADOWLARK Investment Group, LLC as the owner, you did not search Sunbiz, correct? So, and then Mr. Hardebeck had testified that he updated the Sunbiz listing for MEADOWLARK Investment Group with his filings for the years prior to the time in question, prior to the April and May 2015 timeframe, and that the correct address of 13750 West Colonial Drive, Suite 350 in Winter Garden, Florida, was on file, as was the registered agent. So either we can focus either on the mistake by the comptroller's office in searching for a name of a party that was not the owner of the property, and we can give credit to the comptroller's office for all of the efforts that she made in trying to locate someone that was not the owner of the property and notify the owner of the property. Or we can look at the effect of what she actually did. And in this particular case, You have the efforts of Christine Willis that the appellees want to attribute to notifying the real property owner, MEADOWLARK Investment Group, LLC, and actions by the Comptroller's Office to search under the name of 1005 Kimball White Trust and to post in the name of Kimball White Trust and to send certified mailings in the name of Kimball White Trust are not tantamount to providing notice and searching for the name of the true property owner, MEADOWLARK Investment Group, LLC. That error has constitutional significance in this case in that the owner of the property was not located, the owner of the property was not notified, there was no posting in the property in the name of the owner, which may have alerted the tenant in this case. If the Comptroller's Office had taken these same additional reasonable steps in the name of MEADOWLARK Investment Group, LLC, we would not be here today, I'm quite sure, because either MEADOWLARK Investment Group, LLC would have been actually notified of the upcoming tax deed sale, or those notices would have been deemed constitutionally sufficient under the facts of this case. But as things stand, the notices were not sufficient. They don't satisfy the requirements of Jones versus Flowers and the related cases that we cited in our brief, and the tax deed must be vacated for lack of the required notice that was in violation of the due process rights of MEADOWLARK Investment Group, LLC as trustee. I would like to reserve my time for rebuttal unless there are questions that you would like to pose at this time.
No? Okay.
Thank you.
Good morning, Your Honors, and may it please the Court. My name is Adam Knight, and I represent Appellee GVO Investment, LLC. I have discussed the matter with Mr. Posh, attorney for the Comptroller, and we have divided argument with 15 minutes to my client and 5 minutes to his.
Okay. So a little yellow light will come on when it's time for him.
Thank you, Your Honor. I'd like to begin with some of the knowledge that Jeffrey Hardebeck had, and the trial court statement that he questioned the credibility of MEADOWLARK and its witnesses is the prism through which this case should be viewed. We believe that the trial evidence suggested not only that constitutional requirements for notice were complied with, but also that Mr. Hardebeck had absolute knowledge of the tax deed sale. Judge Sawaya, in beginning of counsel's argument, you asked whether or not there was an attempt at posting the property. In fact, what the trial evidence shows and what has not been challenged in any way on appeal is that the property was posted. It was posted on April 9th of 2015 at about 7 o'clock in the morning. Jones versus Flowers specifically addresses instances like this, and it says if a return mail comes back undeliverable, what we do is we say, what else was done by the clerk? And appellant makes a lot of issue over the timing of this, but I think it would be unwise to fault the comptroller in this case, who has, according to the testimony of Ms. Willis, adapted what are pretty reasonable procedures for trying to provide notice. When tax applications come in, they do an initial check, they do an initial search of property appraisers' records, they go through the title report that comes in, and they mail out notices. In this case, if you look at Plaintiff's Exhibits 5 and 6 specifically, the notices went to multiple addresses for MEADOWLARK. They went to the 1005 Kimball Trust at least 2 addresses. They went to MEADOWLARK Investment, LLC at the McGuire Road address that had never been updated by Mr. Hardebeck. And they also went to the prior owner as well, Mr. Singh, who had given MEADOWLARK a deed in lieu of foreclosure. So based on what the clerk looked at and what they did, those procedures in effect were sufficient. And the fact that the posting may have occurred at a point in time where the return mail had not come back is not a significant fact. It's a distinction that does not make a difference in this case. The other reason that the trial court was correct is that the clerk's additional efforts included searches post posting of the property and also post-return receipt of the uncertified mailings. This court has specifically addressed a scenario under which there was a minor misnomer concerning the name of the property owner, and that was the Hutchison case. And in that case, this court concluded that a minor error in the name of the property owner was not going to be something that would invalidate a tax deed sale. In this instance, the error in description is minor. The official name of the owner of the property is MEADOWLARK Investment Group, LLC, as trustee of the 1005 Kimball White Trust. That's the property address. Any borrower or tenant or whoever is living in that property and an officer shows up and posts notice on your door, any reasonable person is going to see that notice, they're going to see their property address, and they are going to know that taxes are due. And in this case, a fact that has been largely ignored by the appellant, Patricia McFadden, the tenant of the property, testified that she in fact tried to contact Jeffrey Hardeback prior to the sale. She knew about the sale. The tenant's mother showed up and actually bid for the property at the tax deed sale. Notice was actually given. The people that should have known about the tax deed sale knew about it. Mr. Hardeback also files, and we presented evidence of this below, Mr. Hardeback has a history of filing bankruptcies in order to stop judicial process. On no less than 3 occasions, we presented evidence of notice of sale, bankruptcy filing. He did it in this case too. Just prior to the tax deed sale of this property, Mr. Hardeback filed a bankruptcy, and his first challenge to the tax deed action came days after the sale, when his attorney sent notice to the comptroller that his client had filed a bankruptcy, and that invalidated the sale. Notably, that argument was abandoned and never presented below. The next time it came up was at trial. And the reason that I point this out is because Mr. Hardeback's basis or grounds for trying to invalidate this tax deed continue to change. His first ground for objection to the tax deed was his bankruptcy. However, that would not have worked because the property was an asset of the trust, and his personal bankruptcy filing would not have caused an automatic stay as to that property. His second argument was that the property was not posted. His tenant filed affidavits stating that property was not posted. We called the officer to trial. He testified that he posted the property. We admitted his notes log as Exhibit 1 and his return of service as Exhibit 2. That argument has now been abandoned in this appeal. They are not challenging the factual conclusion that the property is posted. Now the argument is that twofold. One, that the property was posted before the return mail came back, and therefore that's invalid, but two, also the name on the property. And I point that out to note that the story and the grounds for Mr. Hardeback's challenges just continue to change, and it's because we're faced with a gentleman who will do anything and stop at nothing to keep this property. He went through, and Your Honor asked about did he know the taxes were due. He absolutely did. On pages 120 and 123 of the transcript from trial, he testifies that he knew the taxes were owed for multiple years. He also testifies that he is very familiar with tax deed procedures in Florida. This gentleman knew exactly what he was doing. And I suspect the reason he knew that the property taxes were delinquent is because, like most people, he went online and checked. And when he did that, he would have seen that his property address was wrong, that the name of the trust was wrong. And to come back to the O&E report, the clerk's statutory duty is not to consult the O&E report. They have to order one, but where the clerk is supposed to get its information for the party to be noticed is from the tax collector's rolls. And when the tax collector sent over this property tax roll, it had the 1005 Kimball Trust. And while admittedly that would have been better if they had the MEADOWLARK Investment Group, I don't think it's fatal to this action. Because what Willis's testimony was at trial was that multiple searches were performed. They did go through the official records for this property prior to the sale. They did go through the property and tax collector's records prior to the sale. The only thing they did search for the 1005 Kimball White Trust was Sunbiz, and they didn't find anything, but the Sunbiz search was never required. Jones versus Flowers, Jacalbro, Vasilla Rosado, all cited in our briefs, none of them have gone so far as to require a clerk or comptroller to search exhaustively through the records. And unless the court has any other questions for me, I'll leave the rest of my time to Mr. Posh.
All right, no questions.
Questions?
Thank you. Good morning. May it please the court, opposing counsel. The comptroller largely adopts the argument of appellee GVO. I would just like to emphasize a couple points on behalf of the comptroller. With respect to Mr. McGee's point, opposing counsel's point about the comptroller confusing the name of the owner, we would adopt GVO's argument in that regard in the Hutchinson Island Realty case. In that specific case, the court held that the clerk is entitled to rely on the tax roll as prepared by the property appraiser and tax collector, and it is not the clerk's job to go behind the ownership determination by the property appraiser. In this particular case, it was very similar to the Hutchinson Island Realty case. There was a minor misnomer in the name, but the property was posted, even though there was a misnomer in the name, and the court upheld the tax deed sale in that case. Judge Sawaya asked about whether the property was posted, and I would just note that I don't believe any case in Florida or the United States Supreme Court has overturned a tax deed when the property was posted. In fact, the Supreme Court says that is the single best way for an occupied property and for the owner to be notified, because even if the owner doesn't reside there, as in this case, the occupant will likely notify the owner to protect the occupant's own right to possession, and that's exactly what happened in this case. Mrs. McFadden contacted Mr. Hardebeck after the posting, and she knew about the tax deed sale, had her mother actually attend the tax deed sale to bid for the property.
Evidence that she contacted him or attempted to contact him?
The evidence is that she called and left a message but was unable to reach him. Mr. Hardebeck did testify at trial that he was not told that the tax deed sale was taking place, but the trial judge questioned his credibility on that issue. Also, as far as Judge Berger, you asked about the additional efforts that were made by the comptroller. The comptroller made several additional efforts, checked for updated address for the assessed owner with the property appraiser the day before the sale. Opposing counsel states that, well, that was for MEADOWLARK, but actually, no, that is for the property. And if MEADOWLARK would have updated its address, then the new address would have been there. So it was a check on the property. There was no updated address. That was done the day before the sale. And I would like to point out that this case does fall in the first significant scenario of cases where the taxpayer doesn't update his address with the taxing authorities, and there's no dispute in this case that that was not done. The comptroller also checked the public records for any instruments recorded. The comptroller sent the tax deed notices to several addresses, sent the tax notice to the 1005 Kimball White Trust at the 1005 Kimball White address rather than just at the record address, and then obviously the posting was done. Other than that, I would rely on the brief unless the court has any other additional questions.
Questions? Okay, thank you.
In response to what Mr. Posh said about Ms. McFadden, when there was a question from Judge Harris about did she contact Mr. Hardebeck or did she try and contact him, Mr. Posh responded that she called and left a message. I want to emphasize there is no evidence, testimony in the record that Ms. McFadden left a message for Mr. Hardebeck. That's not what she said. She was asked whether on the morning of the sale, when she tried to reach him, was he successful? And that was in cross-examination. And she said no. There's no testimony that she left a message. There's nothing like that in the record. And that's the sort of thing that
But she tried to contact him. I mean, there's no dispute that she got notice of the sale and that she tried to contact him, is there?
Let's put a fine point on that, the reason that she tried to contact him. She testified, and this is in our reply brief on page 13, that on the morning of the sale, she had no idea what was going on, that there were pictures, there were people that had been coming around, and that I had no idea why people were coming to my home taking pictures for 2 days prior. And then she says, somebody actually knocked at the door to see if they could come inside my home. It was about 7. It was early. It was very early. The dogs barked, so I answered the door. That's how I found out there was a tax deed sale. She says she found out on the morning of the sale from somebody that knocked on her door, not from anything else. That's the substantial competent evidence that's in the record. And with respect to the trial judge, Judge Kirkwood, saying at the end of the case, after he says, I agree with them, I'm ruling their way, and just simply saying that I question the credibility of the defendant's witnesses. What does that mean, and what significance would that have for this court? Does he question them what? Question their credibility on what? On their name? On everything they said, except, the and a? I mean, what are we dealing with in this case? And what's
Whether or not they got notice. I mean, the trial, if the trier, as the trier of the fact, the trial judge can weigh the credibility of the witnesses and choose to believe or disbelieve the testimony of the witness.
He is, and if that's in vogue these days to at the end to buttress your findings rather than with express rulings or pointing out something in particular and giving a blanket, I question the credibility of everything that these people say under the circumstances here. If there was some specific point that the judge could have made, fine. But to just say, I question the credibility of the witnesses, I would suggest that the court should give that little to no significance in dealing with the facts of this case.
We can't step in the shoes of the trial court and judge that. I mean, they're in a superior vantage point than we have. All we can do is read Q and A on a transcript, and so we don't get to see the way a witness testifies and their demeanor on the stand, and for us to be able to judge a witness's credibility. The trial court has the opportunity to do that.
Totally agree. So let's rely on what's in the record, and the record shows that the attempt by the comptroller to notify the owner was not fraught with simply a minor misnomer in this case. Their attempt to search for the name of the owner on Sunbiz was not fraught with just a minor misnomer in this case. Had they searched for the correct owner, they would have found something quite different. And while Mr. Posh is suggesting that the comptroller's office is entitled to rely on the tax rolls, what's in the tax rolls in 1005 Kimball White Trust, the tax collector provided specific information to the comptroller's office by getting an O&E report to make sure the information was correct on the name of the title owner. But the comptroller's office disregarded that with constitutional significance in this case. The comptroller's witness testified at trial that the words MEADOWLARK Investment Group LLC identified a separate entity, which entity was not the owner and instead was merely an interested party. That's wrong. So when the one and only certified mailing to MEADOWLARK Investment Group LLC was returned to the comptroller as to MEADOWLARK Investment Group LLC did nothing further. And when the due process clause of the United States Constitution requires additional reasonable steps, doing absolutely nothing has fundamental constitutional significance, and we respectfully suggest doing nothing further is constitutionally dispositive under the facts of this case.
And you're out of time. Thank you.
Yes, Your Honor.
Right. Court will stand in recess.